Mitigation of damages, only break it down into three parts to summarize what we're going to talk about today. So first, what is it? Mitigation of damages is a term that references a legal defense that the defendant or the at-fault party actually gets to use against the injured party. They get to say the injured party failed to mitigate their damages, meaning the injured party failed to stop the damages from accruing or getting worse by going to the doctor and treating as recommended by these doctors. So, frankly, the question that I get all the time is, why can't I just get the money I know my case is worth right now? Well, if you fail to mitigate your damages, meaning go to the doctor and fix the problems as they're accruing or before they get worse, well, the future pain and suffering damage, that large amount of money that we get to ask for at trial or use during the negotiations phase, it gets wiped away. So allow me to draw up an analogy using a landlord-tenant situation that I believe resonates with all of my clients. If you have any questions, don't hesitate to give us a call.
Hey guys, it's Ross from Rossmore Law. Today I wanted to talk to you a little bit about what's called mitigation of your damages. And if I get a new client walk into my office, ask for help, this is one of the first things I discuss with them. I make sure that they understand what it means to mitigate your damages. And I usually draw a picture for them, and this is a perfectly drawn house, so I don't want to see any haters out there. But step one, what does it mean to mitigate damages? Well, I draw a scenario. I say, listen, you own this house, for example, and you've got a tenant that lives upstairs. And this tenant, they decide to leave to go to vacation for a couple of months. You know that. You're sitting on your front porch, you're sipping your tea, and next thing you know, you see them drive off. 2 hours down the road, they call and they say, there's been a mistake, there's a problem. I left a sink on. The sink is clogged. I know it is. Please help me. Well, you've got a couple of options. One is you could go upstairs, see how bad the damage is to the water, and see if it's only just ruined a corner of the floors. Okay? Or maybe even the whole floor. Who knows? Okay? Depends. Really, how bad was that water going? And two is you could go, hey, it's somebody else's fault here. They left the water on. I'd love a brand new house. Let's just let it leak on down. Leak on down into the floors of the main floor, ruin the walls on the side. Let's go ahead and get that ceiling replaced. Let's just get a brand new house. It's somebody else's fault. It's that tenant who's got enough money to go spend vacation for a couple of months. Let's go after him for a brand new house. Well, no. You had the option at that one particular moment to run upstairs, unplug the clogged drain, and turn the water off. And then maybe, if there's enough damage, the at-fault party, the tenant upstairs, will only owe you for the floors, okay? You can't get greedy and say, no, I'm gonna sit back and enjoy my tea. They're gonna owe me an entire house. It's very similar like that in a personal injury case. You've been injured due to no fault of your own. Somebody else committed negligence. As a result, you've been injured. If a doctor tells you, we can go upstairs and unplug that particular drain and stop the water by going through these particular types of treatments, it's your job to do that. It's your job to get better. It is your job to get back into the position you were in just before the incident, or at least as close as possible. Doctor says do these things, you gotta go do them. If you don't, I'll give you exactly what's gonna happen at trial. The defense attorney is gonna stand up there and say, ladies and gentlemen of the jury, the plaintiff failed to mitigate their damages. They're gonna come tell you that he or she's gonna be hurt for the next several years of her life or on into the future. But they had the opportunity way back after the incident to go to these doctor's appointments, to have these procedures, to have these manipulations, to whatever they needed to do, as according to the doctor in their medical records. They were supposed to do it, they decided not to do it. Don't listen to them when they stand up here and say, I'm going to be hurting for the rest of my life. It happens every single trial. The defense attorney will ask the judge to read in the law to the jury and say, if the plaintiff has failed to mitigate their damages, has failed to do what they were supposed to do, the value of their case goes down. Their future pain and suffering value, it will be minimized, period. That's what the judge says. Now, if you've got questions about mitigation of your damages, give me a call. 844-404-ROSS. We're here to help.
Here are a few takeaways. Just remember, at the end of the day, your treatment affects the value of your case. Sometimes people think, oh, I'm hurt. I know I'm hurt. The value of my case is what it is. Well, to an extent that's true, but remember, your job is to go to the doctor and get better. If we can't prove in front of a jury that you've done everything you can to get better, the value of your case depreciates. It goes down. My job is to make sure the value of your case is maximized. So get yourself into the doctor's office, talk to them, do what they tell you to do. And if you have questions or concerns about what they're advising that you should do, that's what we're here for. Let's talk about it. Let's look at the drawing board and figure out the best plan for you to get better while maximizing the value of your case. Take a screenshot of this, make sure you go over it, and next time the doctor has questions for you, have questions for them. Questions still beyond that, those questions are for me. Give us a call.